This is a newspaper whose function it is to publish, has published. I don't know if national media versus Bogoshi is tattooed on the forearm of every investigative journalist. But I'm pretty sure they're pretty familiar with the fact that that case in particular makes it quite clear that woe betide the journalist who publishes a defamatory statement that turns out to be untrue. On a scale between 100 and minus 100, what are the probabilities of a journalist destroying the only evidence that is available to demonstrate that he acted bona fide and reasonably? I mean, the needle of probability must be pretty close to minus 100. So how on earth was this ex parte application justified?
The South Gauteng High Court Deputy Judge President Roland Sutherland handed down a scathing judgment yesterday that set aside what was effectively a gagging order to prevent amaBhungane from publishing inconvenient truths about the way that the Moti Group of companies does business. Dondo Mogajane, who's the group CEO of the Moti Group, told Stephen Grootes this morning on SAFM that he said he disagreed with Judge Sutherland's ruling and was considering a direct appeal to the Constitutional Court.
We're even thinking, Stephen, now to actually approach the Constitutional Court, because here it's a matter of right to privacy. It's got nothing to do with press freedom.
But he also said that he supports whistleblowers, referring to his experience when he was the Director General of Treasury and how he would encourage them.
I personally support whistleblowing. I personally supported amaBhungane. In the past, I personally collaborated and cooperated with amaBhungane in my previous role. And as I support whistleblowing, I was right at the center of the Gupta Gate issues. I was at the center. I was at the Treasury at the time.
Now, I would like to meet with Mr Mogajane and perhaps facilitate a meeting with a group of whistleblowers that I work with so that he can try and explain to them how he can claim to support them and their cause while simultaneously trying to defend the Moti Group's egregious abuse of legal process in what really is now being declared a SLAPP attack on the media. I really don't know how Mr Mogajane can argue that the group's actions was a legitimate legal option to vindicate their rights. Now, I was in court last week and I arrived a bit late and found myself unwittingly seated in the enemy camp next to Mr Mogajane. I didn't know who he was and we didn't talk, but I sensed that he wasn't liking Judge Sutherland's interrogation of Advocate Vincent Maleka's brave but really impossible attempt to justify the ex parte application that the Moti Group had sought. And Mr Mogajane had a very worried look in his face. I regret I didn't introduce myself, as I really like to engage with people who come from a different perspective. But maybe that can now happen. And to pave the way for that possibility, I would like to share some reflections on the whole saga. In the context of my own very long battle against exactly this sort of abuse of legal process. To kick things off, let's hear what amaBhungane's counsel, Stephen Budlander, said in closing his case, arguing that the entire process was an archetypal slap suit.
This, my lord, is the absolute archetypal slap suit. This is an application brought by corporations with deep pockets in an effort to intimidate the media into silence and to make it as difficult as possible for them to do their job. I don't have to tell your lordship about the judgments in Mineral Sands Resources, your lordship is well aware. I don't have to tell your lordship about the judgment in Morn versus Zuma, your lordship is well aware. But those judgments make clear that the right to approach a court under Section 34 of the Constitution is not a right to abuse that process. It says that a court must take steps to prevent abuse, and this is abuse. It's hard to imagine a more obvious attempt at bullying than this case. And we ask that the court make clear that this bullying is not what our courts are for. You can have a legitimate disagreement with the media, but you don't engage in this kind of conduct. And we would ask your lordship to mulct them in attorney-client or attorney-owned costs.
Now, the landmark ruling by the Constitutional Court that outlawed slap suits, which Stephen was referring to, is the Mineral Sands and others versus Christine Riddell and others' judgment handed down last November. I happen to be one of the others, slapped by an Australian mining company for doing my job as a social worker, which is to challenge social injustices, especially against vulnerable and disadvantaged people with less power. Now, the judgment explicitly now defines a slap suit as something which is based on two criteria: improper ulterior motive and a complete absence of merit. Now, Stephen Budlander was also one of our lawyers and also defended Karen Moore, using the very same mineral sands judgment to great effect to convince the KwaZulu-Natal High Court that Jacob Zuma's action against her was also a typical slap attack. Now, Mr Mogajane also made a confession to Stephen about the challenges he faces, that he was trying to redeem the Moti Group's reputation and that the sins of the fathers should not be visited on their children, and that he was committed to ensuring whatever happened in the past, he would turn things around in the interests of all the employees of the Moti Group and their families.
And I said, give me the space to run, give me the space to exercise what you're asking me to do, to save the future of your children and the future of many employees at Moti Group. I'm doing that. For me, it's an emotional thing. And yes, there is personal criticism from many South Africans. It's fine. But I'm resilient in this way. But again, I'm saying, if there's any speck of wrongdoing, I will certainly move away from this because, and I'm not going to throw my legacy, 23-year-old legacy that I've acquired in the working for Treasury and throw it in the rubbish bin. I'm not going to do that.
Now, I do recognize his good track record of public service when he was DG of Treasury, but my now well-honed social worker intuition is telling me that he is rationalizing. I fear that Mr Moti may be manipulating him and that he's allowing himself to be co-opted into the false narratives of corporate power and is now being used to try and smother the very truths that need to be faced, irrespective of the integrity of those who disclosed them. The courts are there to distill the most probable version of the truth, not to smother the process. Now, I think that Mr Mogajane would be foolish to try and go to the Constitutional Court, because the only thing he will achieve is to give the judges another opportunity to spell out the meaning of slap suits even more clearly than they have done already in the mineral sands judgment, and maybe tighten the handbrake to deter other powerful interests who use lawfare tactics to try and smother the truth. So I wouldn't advise that. It's not worth it, and he's certainly going to lose. I want to suggest an alternative. Far better that Mr Mogajane engages in a restorative justice process instead. I'm happy to facilitate an engagement process for him to come and meet the whistleblowers and maybe some journalists that I know, so that he can hear their stories firsthand of the merciless retaliation and hardship they have suffered simply for speaking truth to power, and why we are astounded that he has lent his good reputation to the Moti Group. If you want to do that, just watch this playlist of conversations I've had with them over the past 3 years on my YouTube channel. There you'll find Cynthia Stimple, Andrew Feinstein, Raymond Hunter, Mosilo Motepo, Temba Maseko, Aris Danikas, Angelo Agrizzi, Karuni Naidu, Martha Ngoyi, Patricia Machale, Sizwe Kuka, and Biswik Kashashwa. Now, there's plenty of testimony for Mr Mogajane to consider. There are many other anonymous whistleblowers who don't feel safe yet to go public, largely because of the bullying and intimidation tactics that Mr Mogajane has been using, and which have made the courts an unsafe arena for human rights to be vindicated. But now that the Constitutional Court has spoken on the mineral sands matter, I think it's maybe time to explain why we have been so successful in outwitting, outplaying, and outlasting our adversaries on the Wild West Coast mining rights controversy from whence that whole ruling came. At least to explain what informed me and guided me personally in my work as a social worker working with the amaDhungane community over the past 16 years to support them in not just opposing the Kolobeni mining scheme, but to ensure that truth is valued. I followed a simple threefold strategy that I got from this book, Soil and Soul, People versus Corporate Power, written by someone who has now become a good friend, Alistair McIntosh. He is a Quaker pacifist from Scotland and tells the story of how two crofter communities from the Scottish Hebrides successfully overcame corporate powers that had had their own plans which they wished to impose on the islanders of Harris and Lewis and Egg. The crofters followed a threefold strategy which defeated those plans. Firstly, naming the powers. Secondly, unmasking the powers. And thirdly, engaging the powers. It's an amazing story, and it explains why in these David and Goliath struggles, David will always win. Because corrupted power has no defense against the truth. That's why they try to suppress it. Now, Alistair got that threefold strategy in turn from Walter Wink, a peace activist theologian who's been very influential on my life, going all the way back to the dark days of apartheid. In fact, it was Walter Wink who helped me realize I could no longer obey further call-ups to the whites-only SADF 40 years ago, and I became a conscious objector. But that's a story for another day. The point that Alistair makes in this book is that the real powers will always try to mask themselves behind decent, pleasant people like Mr Mogajane, to mask the underlying self-serving, highly dubious ambitions. On the Wild Coast, while we patiently named, unmasked and engaged with decent people inside the system, I was able to develop enough trust with sources whose consciences were troubled by what they saw. They helped us peel the onion down to the essence of what was going on. Corporate greed. Of course, that didn't please the real powers behind the masks, which explains why they went after me in what became a steadily escalating defamation slap suit. They didn't like social workers and journalists engaging with anonymous sources inside their companies who were seeking to just liberate the truth. I knew there was always a risk that they would try to take me as a hostage by trying a slap strategy. But it wasn't me they were holding hostage. It was the truth. And the truth, sooner or later, always triumphs. So as a slap suit against me steadily increased from 2 million in 2016 to 10 million in 2019, my anxiety levels didn't rise. They actually dropped. Because I knew the game they were playing. And thanks to Alistair's story of the Hebridean crofters, I knew it would fail. And it has. I also knew that we had something going for us that the Hebridean crofters didn't have. A modern constitution with an entrenched Bill of Rights to guide our judiciary. Now, they have now ensured the truth would prevail. And it has. South African civil society can enjoy a lot more freedom of expression given the mineral sands judgments and the precedents that are now flowing from it. And I just wish Mr Mogajane had ensured his counsel were more conscious of that judgment, because I don't think his lawyers would have advised him to embark on this foolish strategy had they been properly cognizant of what was going on there. Now, I started that work 16 years ago, embarking on this strategy. And never in my wildest imagination would I have dreamt that a court process in which I played some instrumental role would in time be used to defend a journalist against a corrupted president. Now, Mr Mogajane, I don't know you or Zunaid Moti personally, but I'm willing to suspend any preconceived judgment, but I'm seeing the same playbook in operation that the Australian mining company used, which we helped expose. They got people with a good reputation to front up for them. Now, I think you are familiar with the Upton Sinclair quote made famous by Al Gore 20 years ago. He said, "It's hard to understand something if your paycheck depends on you not understanding it." Yes, it is hard. But my experience has taught me that it's not impossible. And I'm convinced that as hard as those with power try to hold the truth hostage, it is not impossible for people to come to an understanding of what's really going on. And really all I did was to provide support, to make it easier. Effectively, the people inside the mining company, many of them became whistleblowers, anonymously. So that helped me ensure that the media knew what was really going on. I mean, that's the essence of a mature democracy, is that we have this active participation of civil society in decisions that affect them. Now, Sam Sol of amaBhungane was especially helpful in exposing the false narrative behind the Kolobeni mining scheme, and his detailed investigation can be read on the link above, which is why I turned out in solidarity with him when Mr Mogajane's lawyers started their slap attack, and when I found myself unwittingly sitting next to him. Finally, my work with the amaDiba also helped me understand another famous saying by Alexander Solzhenitsyn, when he said in the Gulag Archipelago, "If only it were so simple, if only there were evil people somewhere insidiously committing evil deeds, and it were necessary only to separate them from the rest of us and destroy them. But the line dividing good and evil cuts through to the heart of every human being, and who is willing to destroy a piece of their own heart?" So I believe that people are hardwired for altruism and goodwill. And if we appeal to their better angels, it helps those angels spread their wings. Now, whatever Mr. Clinton van Niekerk's motives were, scapegoating him and amaBhungane does not excuse the Moti company's use of lawfare against the media. The end does not justify the means. So, if I may personally invite Mr. Mogajane, if you want to make some lemonade out of this bitter lemon, if you pardon the cliche again, rather than continue this lawfare, come and engage with your adversaries and explore what can be done in the service of truth and justice, instead of fighting a lawfare litigation by attrition strategy. Your interview with Stephen seemed to suggest that that's really what you wanted to do. Well, let's talk.